This is the Thursday, January 9th, 2025 meeting of the DRB. It is 6:32 p.m. And we have as board members present, I believe, in person, we have Patty, Christine, and David, and myself. Diana on Zoom, we have Delcy, Lisa, and Chip. And I think Charlie will be joining us soon. Are there any adjustments to the agenda this evening? None. Are there?
Hi, Diana, this is Lisa Faring. I have a point of order regarding the agenda. And I believe that the hearings were not adequately noticed on the town website. And I know, and while that is not technically a legal requirement, as far as I know, I think it still sort of violates the intent of open meeting laws and giving the public adequate notification. So I move that we postpone the hearings
Is there
until next month.
Is there a second to that? Hearing none, I will, it's voted down. I disagree with you because just so this is out in the public. The town is redoing its website. There have been issues with it. And our clerk is doing everything possible in order to get everything up there. Everything has been posted in the public locations where it is supposed to be posted, including the locations in town. It's been in the Islander. So, and certainly the relevant people with regard to the hearings, including the neighbors, are getting information. So I think the public has been, and certainly it's going to be better when the town gets their website fully working, but it's a work in progress right now. So
okay, I'm glad you pointed that out, Diana. Thank you.
Any public comments? Okay, so we're going to go.
Diana,
yeah.
I think Michael Colburn has raised his hand.
Oh, sorry. Yes.
Yes. So I appreciate the technical difficulties the town is dealing with, but the materials, especially the packet pertaining to the third item on the agenda, were not made available until about 3 days before the meeting. And my understanding is that we should have 15 days notification before the meeting. And I realized that the letter went out, but the materials were not made available until just a few days ago, which I think really, it may adhere to the letter of the law, but it does not adhere to the spirit.
Well, it's my opinion that again, this is unfortunate, but an effort was made to get everything out, and I think we should proceed.
50.
Is the board, I appreciate your comment, but we've done everything we could.
Is this, but this should not be about effort. It should be about accomplished. And you did not accomplish what is required by law. And what we're talking about is just postponing this meeting by 30 days. We're not saying we can't address these issues. We're just saying we need to make sure that we've allowed enough time for this meeting to legally take place.
Well, we have to hear an appeal within a certain number of days. And if we are going to hear the appeal, we have to do it now. Any comments from any other board members? I think the point is the board, by having no second, we technically voted down the same thing that you're saying. So I'm going to make a decision that as a board chair that we're gonna proceed. I appreciate your comments, so. Again, hopefully this is not gonna happen in the future. But every effort was made to get it out, information out, so. Okay, so we're gonna proceed with application 2024-105 DRB setback waiver. Vicky Haley and Pascal Carrier. 1532 Blockhouse Point Road. This is a continuation of a hearing from last month. Pascal is here
Yep.
and
Bye, everybody.
our Christine recused herself as she is a neighbor, but she is an interested party. I will remind both Pascal and Christine that they are still under oath from the last hearing. And so that means that Chip, you are a voting member on this one?
Can you hear me?
Yeah,
Yes.
Well, I can't get my video going, but as long as you can hear me.
loud and clear, Chip.
Okay, so, Pascal, do you have any, would you like to bring us up to date on what's
Yeah.
you've done?
Last time the project I presented, I was asking about two waiver, one from my neighbor's property line and one from the private road. And I did some homework because I was told that from the private road, there was no way we could get a waiver. So I redid the new plan, which include a 27-foot setback from the private road, which is within what was asked me to do. Like it was supposed to be 25. I'm able to give 27 feet from the middle of the road. But I had to redesign the garage and the location of the garage. So I'm a little bit closer to my neighbor, and what I'm asking for the waiver is a, I would say 10-foot waiver from the property line of my neighbor instead of 25 feet. And this way I would be able not to cut any big trees. I'll be able to have the garage I wanted to in the dimension. I'm away from the private road, so it's not a nuisance for the neighbors. So the only thing I moved is the location of the garage and the dimension. I don't know if you had all the paper, the drawings I sent.
And which neighbor is, who's the neighbor that you're closer to? Remind us.
Larry and Nardone.
Okay. Any questions from the board?
Yes, Madam Chairman.
Yes, Chip.
I would like to ask the board to consider that the criteria that is required of the town by our small lot provisions under 9.2. The state law, the statute, I think it's 4412, requires that we have this statute, this provision, and it specifically says that we are not allowed, we are prohibited from asking for imposing conditions on permitted uses that we do not normally do with large lots. Now, in terms of the specifics of how this might play out in terms of the proposed garage, there are two questions, one of which is whether or not the proposed activity can be approved under 9.2. But if we are to impose conditions by conditional use, setback by conditional use, those are conditions that we don't ask of any other properties, and we are prohibited from asking that of the applicant. So although I'm satisfied with the idea that the applicant has modified his proposal, we as a board have to approve this under those conditions, and there are several parameters that are listed in 9.2, including that the lot is more than 1/8 of an acre. But that said, the state recognizes that the development on a small lot will never be able necessarily to meet all the criteria that we would ask of a conforming lot, and they prohibit us from doing so. So if we're going forward, the issues of setbacks simply don't pertain in this issue. And while we might negotiate some details of the proposal, we are unauthorized to impose conditions that prohibit this development.
Lisa?
Yeah, thank you, Chip. This is Lisa Faring. I think Diana, you had and just beg patience from the audience, because this is more of a question of our interpretations of the statutes and our own bylaws. But I think we started this discussion in the last meeting, and Diana, did you get any clarification from VLCT on this?
I did not.
Okay, so I appreciate your comment, Chip, and it makes logical sense that you might not be able to follow the same setbacks if you have a small lot. But where do you actually see in statute or case law or anywhere else that that we cannot require somebody to follow setback requirements?
Well, I'd be glad to go over that if I could just find. I'm having trouble finding it at this point, but let me see if I can pull this up.
Yeah, you know what, Guy, I think that this is something that goes well beyond. We're hearing this case under setback waiver, and I'd like to hear some other board members comment on this, but we could go on for hours on this, and I don't think that's appropriate right here.
You have a comment?
Yes, Christine.
Comment.
Well, I'm
Hold on one
asking.
second, Chip, hold on one second,
I'm
Christine.
not a board member. Can I comment?
Yeah.
Um,
Well, you're an interested party,
I'm
so.
not- right. So I may not be fully understanding Chip, but I'm almost walking away with what he's saying as, if someone wants to build a shed or a structure on a non-conforming lot, they can just do it because they don't even need to come to the zoning or the DRB. And that's what I'm taking from what Chip is saying. And I don't think that seems correct. And then the second thing I'll say is, as a board, I believe we said this in public, or maybe it was in conversations we had about our procedures, but that we were going to listen, take applications and listen to, in the hearings, and relate everything to the regulations and not statute. That our regulations are derived from statute and compliant with statute to the best of our knowledge, but that we were gonna not allow these hearings to devolve into debates about statute or going down rabbit holes to find the statutes.
Christine, this is Lisa Faring. I'm sorry. I didn't mean to cut you off. Are you finished?
Sure.
I apologize. But I do want to point out that it actually is in statute that we include statute. Okay. So I don't think we could have made that decision.
Am I wrong?
I'm
David,
not
did you have-
Smart enough to know if you're right or wrong.
David, did you have a comment?
You know, Jeff,
Well,
I,
I would like to,
Excuse me. a
I
minute,
would
wait,
like to
Chip,
say
hold on,
that that
Chip,
Christine's comments are welcome, but I would remind the board that she's an interested party. And I don't want to belabor this, but I would like to read the statute.
can we hold off on that, Chip? David,
Well-
go ahead. But wait, hold on, Chip, hold on. David's got a comment. Hold on.
All right,
Chip, what I was gonna propose was, I think that this issue is really important and very critical. And it may have bearing on this particular application, but this is an application that we have reviewed once and we have accepted to review in this hearing.
As a setback waiver.
Yeah, as a setback waiver, I'm thinking that what I would like to do is propose that we take this issue, which is an important issue, and discuss it as a potential opportunity to define with greater clarity in the bylaws. If we want to make a recommendation to the PC about how to describe this.
well, I'm amenable to that as a solution, but only to the extent that it does not violate the statute, which I would like to read. And I would point out that the board is exactly capable of amending an application and how we hear it. And I can think of at least 3 or 4 specific instances where the members of this particular board did exactly that. But let me just read existing small lots.
But what,
Any lot that is legally subdivided is an individual and separate and non-affiliated ownership from the surrounding properties.
Chip,
And
hold
is
on.
in existence
Chip,
on
hold
the
on.
date of enactment of any bylaw, including
I
an
know.
interim bylaw, may
Chip.
be developed for the purposes permitted in the district in which it is located, even though the small lot no longer conforms to the minimum lot size of the new bylaw or interim bylaw. So
Chip, hey,
with
Chip,
that in mind, if we don't impose anything we wouldn't on a normal lot, on a normal development, then I'm okay with that.
I think if David is making a motion on are you making that as a motion?
Well, Chip, are you amenable to that?
I don't,
Well, I don't know exactly what it exactly means, but to the extent that it provides a solution for Mr. Carrier, and if the board finds his proposal acceptable, then we are not imposing anything on him that he isn't proposing himself. So if that's the case, then that's a solution.
well, we're gonna, then,
This is Chelsea. Can you hear me?
Yes.
Okay, I want to bring us back to our bylaws to start with, which give us clear indication in 6.2 A, section A, item 2, for structures on non-conforming lots, the DRB may approve a reduction to yard setbacks. It sends you also to Article 9, regulating nonconformities. But we have clearly right here in our bylaws, the approval of, or to meet our bylaws, we can approve a reduction to the side yard setbacks. And that's all that is being asked in this case. And I move that we go forward with it in this case and have our statutes discussion aside from proceeding with this case.
Is there a second to that motion?
I second.
We have 2 seconds on the table. Okay, all in favor, say aye.
Aye.
Aye. All opposed? Okay, so thank you, Delcy. We're going to move forward with the case.
Is
Assistant zoning administrator, am I entitled to make a comment or not? I'm not an interested party. I just wanted to point out one of our regulations, which may have an impact. on
but
this.
we've already voted to
Okay.
proceed.
Right.
However, in the full discussion,
Yeah,
I think the board would welcome your input.
okay, thank you.
Okay. So let's proceed with this. Are there questions for Mr. Carrier on his updated plan? Where he is seeking a
It's
setback waiver of 10 feet.
It's a 10-foot waiver, yeah.
This is Lisa Faring. I'm sorry, I'm still looking for the updated plan. Is that a new exhibit?
Exhibit G.
Exhibit G.
Okay, thank you. I'll see if I can find it.
The setback shows on the drawing as 14 feet, but
Just want to have a little leeway. If I can get 10 feet, I'll probably be around 14, but just to make sure.
So maximum of 14, a minimum of 10. But,
Yeah. But there's
does the
actually no
neighbor,
max.
does the
There's
neighbor
actually,
have an issue with this? Have you talked to the neighbor?
I talked to the neighbor by phone, and he's got no issue at all with this.
Okay.
That's not me.
No, that's
Yeah.
that's not Christine, that's Larry.
Okay. Are there any other questions then?
Not a question, but this is Delcy again, and I found the other statement, took me a while, but in section 5.5 E, administrative waiver for pre-existing non-conforming lots. For pre-existing non-conforming lots with not more than one dwelling unit and no accessory dwelling unit, the ZA may grant a 10-foot minimum setback for not more than one accessory structure when all the following can be satisfied. It is from the side. This one doesn't apply because it's more than 150 square feet. Sorry, I apologize for taking your time.
That's the small shop.
Okay,
So we only have the 6.21. I
Okay.
apologize.
so if there are no other questions, as an interested party, Christine, do you have any comments on the change?
I think that Pascal and Hickey were responsive to the board's last concern about the midway to the private road. And I think that was a concern of neighbors that, it's a very narrow one-way. So no, that was addressed.
Okay. Is there a motion to,
Can I move that we close the hearing?
David moved that we close the hearing. Is there a second?
I second.
Patty seconded. All in favor, say aye.
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 Oppose? Okay, so the hearing is closed. We have 45 days to make a decision. Usually it's a little bit before then when we get it out, but you will be hearing from us then.
Okay,
Okay?
okay, thank you very much, everybody.
Thank you so much, and thank you for your efforts to, as Christine noted, to respond to the original comments from the board and
Okay.
concern.
Thanks, and good luck for your bylaws.
Did you want to be on the board? We have an opening.
That's all right. Thank you very much. I'm gonna leave the hearing. Thank you.
Okay,
Okay,
we
bye-bye.
close the hearing at 6:57. We will open application 2024-108 DRB conditional use review, Tanya and Chris Retz at 3547 Lakeview Drive. At 6:58.
Lisa
Tanya,
Faring,
Yes.
Diana, this is
Yes.
Lisa Faring. Another point of order. I believe this is not appropriate for the DRB to be considering, given section 1.4.1E of our bylaws, which exempts agricultural uses and specifically E. See if I have that. E, sorry, I've got too many things open. E is that the on-site, so let me start with the beginning of that section, which is except
Lisa,
for
what-
1.4. So 1.4, it starts out saying, except for development located in flood hazard overlay district, the following uses and structures are specifically exempted from municipal land use and development regulations by Vermont state law. No municipal zoning permit or approval under these regulations shall be required. Other state or federal permits may apply. Then it goes on to list them in section 1. Required agricultural practices, including blah, 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 blah.
down to E.
Down to E. And E is, well, A is the Christmas trees, and then E is on-site storage, preparation, and sale of agricultural products, principally produced on the farm. I think the application was considering that a retail establishment needed conditional use approval, and I believe that this exempts that particular type of agricultural use.
Comment from the board.
I thought the store was for, not for their agricultural products. The greenhouses are for the agricultural products. Maybe.
Do you want to get
But
an
this-
initial, we have to give them the oath if we're gonna.
Oh,
Lisa, may we at least proceed enough to give them the oath and then let them respond to your comments? Because I think you brought up something very legitimate here.
Okay, sure.
Okay, so, would the two of you like to take the oath from us then? Let me get back to that, sorry.
Here, come on up to the table.
Yeah, if you'd like to, it's easier to. Are there any, I should first ask, are there any interested parties in this?
Yeah, I'm Chris's neighbor,
Okay, and your name, sir?
Blaine White.
Blaine White. So you would like to be an interested party in this?
Yeah.
Okay, so I need to, you don't need to come up, but you need to take the oath also with us. So, okay, so for the three of you, I hereby swear that the evidence I give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury. Okay, okay, now, so I think in response, Patty, do you want to go ahead and ask your question
Well,
then?
I see that the application says retail space and then it says nursery. I mean, but, so are you going to be selling like plants in there, or are you going to be selling like pottery, you know, put plants in, you know, I mean, that kind of question is what comes to my mind.
Basically a full service garden center is what we would like to develop it into. So, sales of things like mulch and topsoil, by the bag and, potentially fertilizers. For folks.
Okay.
You know, things that are garden or plant related,
Okay.
potentially pots and things like that as well. But also our plants that we grow.
Okay, so it's a mixed use kind of commercial thing then, it's not just solely agricultural products from your
Correct.
property?
Correct.
Okay,
Okay, this is Lisa, Lisa Faring. I withdraw my motion.
But I think that's, it's an important thing to think about, because I think, part of, as I understand the application, part of the application, you may be correct, Lisa, in saying
it's
is,
a Christmas.
it, you know, talking about the Christmas trees, that's, we should not be ruling on that.
Although it does say cultivation as opposed to retail.
It would be we'd be growing them and then retailing.
And then retail.
Yeah.
So I think what I'm suggesting is that the cultivation is excluded,
Right.
but the retail would still come in.
Well, no, because it says under here, it talks about the sale, so. Okay, so we'll proceed then. Are there, for the board members, are there any conflicts of interest or ex parte communications on this? If not, then Charlie's still not on, right?
I don't think so.
Okay, so Chip, would you be willing to be a voting member on this if
Yep.
Charlie is not here?
Yes,
Okay, we're just verifying that. Okay. Okay,
I just want to correct myself.
yes,
I misspoke before. The on-site preparation and sale of agricultural products principally produced on the farm.
Yeah.
Are exempt.
okay. So, okay, so would you like to just walk us through then? What you're planning on doing, and obviously, we're just talking about the retail store here.
Yeah, so we are looking forward to. Currently, we have 2 greenhouses and I have traditionally used them to grow product for my landscaping clients. And we would like to expand that into doing retail sales of things like annual bedding plants, vegetable starts, perennials and shrubs. Also carrying bagged mulch and you know, bagged soils. Not doing anything bulk yet at this juncture. I think that, anything else to add?
Just having a retail space where customers can come, pick out their goods.
Okay, are there questions from the board?
Diana,
Yes, Chip?
they should have addressed parking.
Yes, we've got parking and signs also, and the.
I read 10 spots or something.
Yeah.
Right?
I think we have 8 spots.
It's on the staff comments.
Yeah,
And then at the main house would be where we would ask employees to park. So we would be trying to negate that need for employee parking on that side and doing that at the main house.
And there are no wetlands, correct?
No,
In
I
that-
have been in contact with wetlands. I have a printout of the back and forth. Basically, the end result of the conversation is, I'm just trying to find it so I can tell you the person's name. Elijah Schumacher.
Yep.
The end result is he does not see any need for wetlands, even though we do have wet areas near the back of the property. We'd like to walk with the two of us when springtime comes and define where we can and cannot plant Christmas trees or native
Okay,
plants.
But since we're not talking about the
Yep.
planting of your trees, we're just talking about the
Right.
business.
As
There's
a-
nothing,
Right, as far as in the business
Yep.
area, no.
okay. So, does anybody have any questions, concerns as far as parking?
You know, at this point about how many employees you anticipate?
Me and my son.
Family is always the best labor.
I don't know if I can handle that.
So I thought the sizes of the parking spaces were specified in our bylaws and some of them.
Once,
So, yeah,
it's right here.
but I don't see the dimensions on the drawing, you know, of like
Oh.
that.
I spaced those, I believe, for 12 foot by
Okay,
16 foot.
okay, okay.
What was it, 12 by
I believe it was 12
by 16? And as far as signage, what signage are you expecting to?
As of right now, I'm probably just gonna put a sign on the side of the retail space. And then as time goes on, then probably get a permit for one by the roadside if it's needed.
Okay. Any other questions from the board?
I think you have a board member on mute.
Is she saying something?
Wait a minute, Delcy, we can't, you're on mute, Delcy. We can't hear you.
I'm unmuted now, sorry.
Okay,
I
Thank you.
assume that you're expecting the retail operation to be in daylight hours and not requiring any type of lighting?
That's a good question, correct?
Okay, thank you.
So you can't buy a Christmas tree in winter at 4:30. Yeah, might think about that.
That's a fair thought,
What about Christmas cows?
And hot cider. I want hot cider.
That's the plan.
What is your thought
I
on lighting?
think that during the winter time, Christmas trees, I mean, we're gonna need lighting, at least for what, November into the middle of December, Christmas. And then before, yeah, December 24th. So we probably need minimal lighting to make the parking area and walkways lit enough during the open hours. After that, so.
I mean, I suspect people wouldn't go into the grove and cut their tree in the dark, but you're
Right.
talking about trees you already have cut. That
Yeah.
would be another place.
Yeah.
Little bubble lights.
Mhm.
And there are concerns with, 7.4, with making sure that lights don't shine into neighbors' properties and,
Yeah,
Light
it would
is
be just-
pointed
it would
down.
Just be downlit.
yeah. So,
No more intrusive than Christmas lights.
So the lighting requirements just say outdoor lighting shall be kept to the minimum required for safety, security, intended use, consistent with the character of the neighborhood. Permanent outdoor lighting fixtures should be deemed to minimize glare. And then again, not upward and.
Do we
Okay,
need to review a plan for the lighting? I mean, is that,
How close is this to neighbors?
Our closest neighbor to where this is going to be
This location.
is, I believe, about 225 feet.
Yeah. I think that's what they're doing her home,
Yeah,
and
because
she actually doesn't have any windows that face our side either.
is anybody across the street?
yeah, but they're protected by tree line.
Okay.
So I'm looking at this.
Yeah.
Are you building a building?
Yes,
Mhm.
this 16 by 16.
Okay, that's the new thing.
There's
Yeah.
another drawing that it shows that on near the back,
Mhm.
yeah.
So that's the retail sales building.
Mhm.
This is Delcy again, and I'm losing my voice, but I have a second question. And that is, with the parking area now established, or that would be established, do you have the appropriate, checked with the roads in terms of the road access up onto, Lakeview?
Yeah, currently, we already, about 4 years ago, that driveway was permitted and put in.
Okay, thank you.
can we hear from, Mr. White? Do you have any concerns? Comments?
No, I don't have any concerns. So.
Why are you here?
Two things.
He is a
My
right
neighbor.
to be here.
I know.
And I've never been to one of these.
You may be a member, be nice.
We have an opening.
It's interesting.
So,
Yeah, so no, yeah, yeah, it's. Seems fine to me, so as I said, that's why it was kind of like, seeing how this all works and everything else, so.
okay,
So.
okay, good, thank you.
Oh, sure. Your mama's gardens too, right?
Yes.
I figured by the mama's blossoms. Yeah. Won't be two mamas.
Any other comments? Questions? Nobody online, no questions? Lisa, Chip? Kelsey's? None? Any motions?
I motion to close the hearing.
I'll second that.
David moved, Christine seconded to close the hearing. All those in favor? Say aye.
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 All those opposed? So we'll close the hearing at 7:16 PM. Again, we have 45 days to get a written decision out, and we will do so.
Thank you.
Thank you.
Okay, thank you so much.
Thank you
Thanks for
for
coming in. Thank you. Thank you.
for your time.
Thanks for coming in.
Yeah.
And we have an application ready.
You want to sit at the table?
No, I can't take on any more than what I got going on.
And you think we're joking.
No, I'm not, you're not joking. That's why I can't take on any more.
I have a thing right here.
Give me about a year.
They'll hold you to that.
You
That's all right.
you see how much fun we have.
In a year, so.
Okay, so,
Take care. Yeah. Bye.
Yes, I got an arm.
okay,
Do you want me to check?
yeah.
I did see him. No. Yeah, he's on.
Okay. Well, because, our DRB clerk, well, let me announce that the next, hearing is an appeal. It's application 2024-109 DRB zoning decision appeal. Owner Brian and Catherine McKenzie, applicant Marie Quinton and Scott Jackson, 26 Briarcliff Drive. Because the DRB clerk is also the zoning administrator for the town of North Hero, she is stepping away from the table to sit in the public seating with her ZA hat on, and she will no longer participate in this as the DRB clerk. So she will not be sitting up here. She will not be participating in any decision-making, any deliberations of this. An appeal is a little bit different. Before we get a list of who's here, I just want to be clear on this to everybody. An appeal of a hearing is a little bit of a decision, is a little bit different than a normal hearing that we would hear. It's a little more formal. We will ask, we will start out by having an explanation from the zoning administrator on the decision. We will then go and ask the appellant to speak. We will then ask the landowner to speak. We are asking that all address their comments or questions directly to us, that they are not questioning each other directly, as we usually allow in a hearing. We, as usual, ask that all be respectful in their comments and in their questions here. And before we get into any further details, we need to get a list of, make sure everybody is present. We have the zoning administrator and the assistant zoning administrator here, Danielle and Andy Holling. And then we have Brian and Catherine McKenzie are both here. Marie Quinton and Scott Jackson. Marie is here. Is Scott here also?
He's.
Yeah. Yes, I'm here.
Okay. I'm having to run this machine here, so sorry, people are going to bear with me. Huh?
Can I sit over there and help?
Sure. That'd be great.
Is Scott Jackson here?
Yes, he said Scott was here. Now, for a list of interested parties, would you like to be interested parties?
Yeah.
Okay, so Mr. and Mrs. Andre Quinton are interested parties. Oh, that's you.
That's me.
So you're taking notes.
Well, I can do it too right here.
And then we have people, anyone online who is an interested party on Zoom? Mr. and Mrs. the Colborn? And then,
Sorry, is Michael Colburn an interested party?
yes,
Michael
And-
and your wife's name, please?
Nancy. Nancy?
Nancy?
We're at 24 Briarcliff.
and we said Mrs. Quinton, and your name is, what is it?
Karen.
Yeah, I mean,
Oh, wait, how do I get to participants? I want to see who's online. Anybody else on Zoom that is gonna, what do you want to do? I want to get to see who's,
Participants is on the bottom right there next to more.
more.
oh God,
No.
participants
yeah.
right here.
Okay.
Thank you.
And-
It doesn't give us a,
Okay, now go to.
Sorry, everybody. This is what happens when,
You don't want to stop recording? Cancel. What are you trying to do?
I'm trying to get a list of who's online, who's on Zoom.
But we haven't.
Sorry, I also Hans Hussey is, I think he's on as well, our lawyer.
That's what we're trying to figure out here, who's
I don't see.
Click on more.
participants. There we go.
Yeah, it's down at the bottom, guys. There should be a thing in the little up caret.
Yeah.
Get the list on the right.
There he is. Okay, there he is. Okay, yeah.
There it is.
Here, but I'm not an interested party. I'm just here on behalf of the Mackenzies.
But if you are going to testify, are you going to testify?
I'm not going to give factual evidence. I'll argue the law, but that's all.
Is he their lawyer?
Yes,
Yes.
I think we need to sign you in. Is that as an interested party then? Do we not, Michael Tarrant, who is our lawyer?
No, he's not an interested party. He's just their counsel. So he's just representing them. And he'll just probably speak on their behalf most of the time.
Does he need to take the oath?
No, not unless he's going to give facts.
Okay,
It doesn't hurt, but he doesn't need to.
okay.
Do you want to make that go away?
Yes, please. This is way beyond my pay grade. Okay, so for the main parties and all interested parties, then I'm going to give you the oath because this is a brand new hearing. Everybody ready? I hereby swear that the evidence I give in the cause and under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury.
Yes.
I do.
Yes.
Okay.
David, can you note that I was trying to?
Yeah.
Thank you.
Are there any conflicts of interest or ex parte communication as far as members of the board? So Chip, with Charlie not being here, are you prepared to be a
Yes.
voting member? Okay. Okay, so
1 second. I was doing this, so I have the Whittons and the Colburns. Are there any other interested parties?
no.
No.
We have
Just the lawyers.
the lawyer here.
Quentin, the Coburns, and the Mackenzies are all in.
Yeah.
We know, yes.
All right.
But you're part of the hearing here, part of the appeal. You're the owners of the property, so you're automatically here. I think to address it right up front, there are two concerns here that have been raised. One is the timeliness of the appeal, and one is the appeal itself on the decision. I think we're going to address the timeliness initially, but we will not make a decision here. That will be part of the board's deliberations. So we are going to hear both. We're going to hear testimony on both the timeliness and on the facts of the appeal of the decision itself that is being appealed. Is that clear to everyone? So, as far as the process here, I'm going to ask Danielle as the ZA to let us know the timeline of as she knows it for what occurred here.
I believe it was October sixth that Marie submitted a zoning complaint. Excuse me, I have 30 days to investigate, and I began the initial investigation. Not long after that, I drove up there to take a look. I don't remember which day it was, but it was in October. To take a look and see if any driveway had been put in, and it was not. When I did, I think Marie emailed me to ask me for an update because I hadn't responded to her. And I think it was not until November 20th. I think it was November 20th that I emailed her back and stated that I did not see that any unpermitted work had been done or any driveway had been put in, and so I didn't find them in violation of any bylaws.
So the decision was on November 20th.
I believe so. It's in the packet there, that
Yeah.
email.
And proceed, what other dates?
So it was that, it might have been that same day that Marie emailed me in response to my email and said that she respectfully disagreed. At which point I advised her, or I suggested that she submit a zoning appeal application.
Is that in an email that you asked her to?
Yes, it may, I think it's in the packet. Maybe not.
Okay, so what we have here is, I suggested that she submit a zoning appeal application via email. Okay,
That means I suggested via email that not that she submits it via email necessarily, but I suggested via email that she submits one.
okay. And then, what happened after that?
She submitted the application to the town office, not to me. I believe it was December 11th. And I think Corinne responded, the town clerk responded on the 13th, stating that there was a fee involved with the application and that it wasn't complete until the fee was paid. And then I believe Marie called to pay over the phone on Monday, the 16th. At which time Corinne gave a copy of the appeal application and all the supporting documents to me.
Okay, thank you.
Yep.
Marie and Scott.
Can I ask
Uh,
a clarifying question?
Clarification.
Yeah, and Danielle, I'm sorry, you said that what was the email dated?
With the one that
That you.
the decision, I
yeah.
think it's November.
Not the decision, I'm sorry, the one that where you suggested that Marie submit an appeal.
I don't know.
It was December 11th.
Okay,
So November 20th, when you sent me that, you told me that they didn't find there was a violation. You did not say anything about an appeal. And I further sent an email requesting
We're not.
Oh, I'm sorry. I thought you were asking when it was done.
No, sorry, excuse me. You're gonna have a chance to testify in a
Oh,
second.
okay. Sure. I thought he was asking. I apologize.
No, thank you. Again, we have to be a little stricter on this, not quite as freewheeling.
So Danielle suggested she submit a zoning appeal on,
December 11th.
which it looks like Marie did right away.
Which was
Yes.
done on the day
that
of,
same day, yep.
okay. Okay, all set?
Yep, thank you.
Okay, okay, Marie and Scott, would you like to comment on the chain here of dates?
Yeah, I'm not sure, what the, I guess we weren't told, the only reason we found out a decision is because we continued to email to ask because 30 days had passed and we hadn't heard. And then we were told, and I guess I just didn't understand the process in North Hero, that when there is a zoning complaint filed and there's a decision made, there's nothing made public about that decision. It's not posted anywhere. Is it usually sent just by email and then you're supposed to appeal? There's not quite a procedure laid out.
Do you agree with the dates as submitted by the ZA?
That on November 20th, she replied to me that she didn't find a violation. And then on December 11th, she suggested that I complete and submit a zoning appeal application, which was done that day. The only reason it wasn't paid on the 13th was because the office was closing when we were notified, I think at 11:30. And so that's why we waited till the Monday. We had emailed Corinne back that we'd call her on the Monday because we didn't want to delay people from leaving since it was 11:30 when we were notified.
Yes or no?
That she does agree. Yeah. So again, you agree with the dates?
I agree that
Yes,
we were
it's-
notified on December 11th to file an appeal.
Yeah. Which was filed that day on the 11th and
Yes.
will technically not totally finalized until it was paid on the 16th. So, okay, thank you. Are there any, I don't know that there's a reason for the Mackenzies to comment here, but are there any thing from the Mackenzies on the dates?
Well, I have no idea about the different dates. We got this packet 3 days ago.
We knew nothing about it.
We didn't even know this was happening until we got the letter about less than a week ago.
Wait a minute, I'm sorry, we're not opening it up to interested parties yet.
Oh, I thought you asked us a
You
question.
asked the Mackenzies.
I was asking the Mackenzies.
Right.
Those are the Mackenzies.
Mackenzies, I would just say,
That's
We
the
had-
Coburns, I'm sorry, we've got the Coburns speaking over here.
No, we don't.
I was just pointing out that the Mackenzies were speaking. That was my only point.
Okay,
And we didn't know anything about it until we got the letter, and we didn't even see the packet until 3 days ago. So we knew nothing about any of the complaints or anything until just recently.
but we would
So
like to
it's-
obtain, we would like to make sure that we have interested party status with respect to the timeliness issue, because that wasn't explained in the package of materials that was provided, and we were not prepared.
I'm not sure who's speaking, hold on.
This is Mr. Husey on behalf of the Mackenzies.
Okay, I'm sorry, we can't see you, so if you could
Are you with
announce yourself.
Galaxy
as you speak.
S9?
All right.
No, Galaxy X9 is still.
Oh,
speaking.
there he is.
Okay, there he goes, okay. I'm sorry, sir, could you repeat yourself?
We just want to make sure that we have interested party status with respect to the timeliness issue also. We would have been here today ready to comment one way or the other if we had been advised that there had been a second issue with respect to this appeal. We were only aware of the appeal itself having to do with the alleged zoning violation.
Can I ask what the timing issue is?
There is, according to regulations, and I will read it to you. Appealing decisions of the zoning administrator. The applicant or any interested person may appeal any decision or act taken by the ZA by filing a written notice of appeal with the town clerk and filing a copy of notice of appeal with the ZA within 15 days of the act or decision.
So is a
The,
decision a
the,
decision?
the notice of appeal will not be considered complete without the applicable fee.
I guess procedurally wise, if you file a complaint with a zoning administrator and you follow up with them 50 days later, although it's supposed to be made in 30 days, to find out what the decision is or what they're thinking, and they say they don't think that there's a violation, but there's nothing filed anywhere, there's no formal anything, that's considered the zoning decision, and then when you follow up to ask what the next steps are, you're told on December 11th to file an appeal, and you do that day. I'm not sure what the timing issue is.
Technically, which is why we're asking about the dates.
Mhm.
The decision was on November 20th. The appeal with fee paid was on December 16th, which is, I believe 25, 26 days after the decision.
So does it
And
matter the decision was 20 days late? Since the regulations require 30 days?
The ZA decision doesn't require.
The ZA decision is supposed to be made within 30 days of a complaint being filed. And usually it shouldn't take the complainant following up numerous times to see what the decision is.
So what is the date that was your official?
October
It
6th,
was October 6th, and the decision was
November 20th. If that's the decision, I guess the process, I'm also wondering what the process is in North Hero. If you file a complaint, is it just you get you follow up and you continue to follow up, and then you get an email that says, I've decided, that there isn't a violation? And because it's not like other procedures in town where there's something filed and you can notice it and you can say, okay, now I have 15 days to respond. That doesn't occur. So it's hard to determine if that's actually a zoning administrator's final decision, that then you have 15 days, which is why I followed up with the emails requesting more information on what steps I needed to take. And that's when I was informed what steps I needed to take.
okay. Thank you. Board members, do you have comments or questions here?
Yeah, this is Lisa Faring.
If you have can I just ask if any board member has a specific question, can they address it to the appropriate person?
Okay, this is Lisa Faring. Diana, why are we considering something that's not included on this application? That is the timeliness. That's not a part of this application.
Application being the appeal, you mean?
Yes, yes.
Because the regulations say that it must be made within 15 days. What we're hearing is extenuating circumstances. This is part of, as we deliberate, we have to make a decision if the steps were followed according to our regulations.
Where are zoning decisions published, or where are they placed so people can know they have to appeal?
Hold on, one question, one moment here, Marie. We're gonna have the board ask questions, and then we'll come back around. Are there any questions from any board members?
Just clarify, a point of clarification. The McKenzies withdrew their application to the DRB, correct?
Mhm.
I'm right.
Yep, so you're wanting to know what the zoning complaint was?
So I just want to, so.
The complaint has nothing to do with that. I guess.
Okay, excuse me,
I'm trying to process something, Marie, if you bear with me. Sometimes I'm a little slow. The Mackenzie's application to the DRB was withdrawn. So from our point of view, it was over.
No, but we're not talking about.
I know.
Okay.
So I'm just thinking.
Yeah.
What happened next? So.
Why?
what
are you
happened
asking-
next?
Are you
Hold
asking
on one
a
second.
question, Mackenzie's?
So, sure, anyone can answer that.
Can I answer since I'm the applicant?
Wait a minute, who would you like to direct it to?
So what happened next, Marie, after the application was withdrawn? What exactly was the next step and who took that step?
The next step, which this is what I believe is this is a separate, right? This is a separate number. This is not a complaint based upon their application or having anything to do with the waiver. This was a zoning complaint for using an unpermitted driveway.
Okay,
So
so,
that's the complaint that was what they were using an unpermitted driveway to access.
so what happened next was the letter that you sent into the town saying that, the
I was
Mackenzies.
told to file a formal zoning
You were
complaint.
told to file a formal complaint by our zoning administrator. Okay,
Mhm.
thank you. And then going back to,
So that was filed on October 6th. I followed up for several weeks from November 6th until November 20th. When I was told that there wasn't a violation and I wasn't sure what next steps were because the decision was not posted like a formal decision would be. So where one could look and say, I have 15 days, such as, what perhaps is done in other towns where things are a bit, are filed so someone could see it. And so when I followed up with the zoning administrator, I was told on December 11th to file a zoning appeal to the DRB with instructions on
would
how
it
to do
be-
so and a copy of the application to do so. And I
okay,
filed
so would
that
it be
day.
would it be your contention, Marie, that, you met the, requirements in the regulations that Diana is pointing us to? And that you did in fact file the, complaint, within, the appropriate timeline?
I filed the complaint
That's a
as
yes or
soon as
no
I was
question.
told what the proper.
That's a yes or no question.
Yes.
Is it your contention that you
Yes.
filed the complaint within the appropriate timeline?
Yes, it is my contention that it was filed within the time that I was notified.
Okay, thank you.
Okay, if there are no further questions or
And I
comments.
have a question.
Yes, Chip.
I've been over the exhibits and I do not see a complaint to the zoning administrator in the exhibits. I see reference to a complaint beginning on October 6th, but I don't actually see the complaint that is referenced there.
Say something about that?
The ZA, yes.
So the zoning complaint was submitted electronically on the brand new website. And there's no way for me to turn that into a document to print it out. I might be able to like take a snapshot to, like a screenshot to send it to you, but I actually couldn't even access it for some time. I knew it was there because I got the email saying that it was there, but there's no way on the website right now to turn that into like a document that I can print out and distribute, fortunately. Like I said, we're having significant problems with the website.
Yeah.
So I think we've got the timeline down now and all the comments. So I think we will proceed at this point to the actual appeal.
Excuse me, on behalf of the Mackenzies, we would just
Yes.
be on the record as stating that we don't believe the appeal was timely filed. We don't believe that the explanation that Ms. Quinton didn't understand the timing of the appeal is legitimate. Ms. Quinton is, I believe, an attorney. Ms. Quinton is represented by counsel in a related matter adverse to the Mackenzies and has the advice of that counsel and could have counsel.
Wait,
timing of
hold
the-
on.
Marie, let me finish. And therefore, I don't believe there are extenuating circumstances, and I think the board would be fully within its rights to hold the Quintons to the timeline set forth in the regulations.
This matter
Okay.
has absolutely nothing to do with the other matter. I'm not represented by counsel. That has nothing to do with that. I'm letting you know that as soon as I was told what to do, I did it. And so
Oh,
there's nothing else I
okay.
can do.
Okay, thank you for everybody. We're gonna move on to the actual appeal. And once again, I'm gonna ask the ZA to explain the basis of the complaint and the reason for the denial.
I drove by the property and
What, can you start off with what the complaint was, which
Oh, the
required you to
the
go.
complaint was that the Mackenzies were accessing their property, and parking their cars and utilizing areas of their property that were, not adhering to setbacks. I believe Marie stated that they were parking within 10 feet of the property line. Excuse me, so that was the basis of the complaint, and that they and guests of theirs at their house continued to access their property this way and violate the setbacks. So my decision was that when I drove by and based on the regulations, I determined that they did not complete any permitted work, unpermitted work, and they did not install a driveway.
Okay, Marie and Scott, as the appellants, we invite you to now speak to this, to the complaint and then the appeal.
Okay. What the complaint was for was continually utilizing a non-permitted access and non-permitted driveway to their house that didn't meet setback requirements. It doesn't meet setback requirements for 3 separate properties: the John Quinton Trust property, the Quinton Point condo property, or 54 Briarcliff. And the town regulations state that all accesses serving not more than 3 lots shall be considered driveways and shall comply with the driveway standards in subsection B below, which requires the 25 feet from all property lines. This is not being met. There is, it doesn't matter whether the driveway is gravel, dirt. It doesn't matter what it is. It's the function and the location that matters. And the function is to access their house from Briarcliff Drive. The access to their house that they're using is not within the setback requirements, which they're clearly aware of since they applied for a setback waiver for that area to build the driveway. And just because there isn't, the regulations do not require that there be gravel. It doesn't require concrete being poured in. It simply is the access point. And this is the access point that they're using. The state regulations also don't require that. It's based on function and location. It doesn't matter whether it's dirt. If this was the case that anyone could just drive wherever they wanted to as a driveway, if they didn't put down gravel, then why have the regulations? Someone could drive, a foot from your property to access their house continually, and there would be no violation.
And Marie, this is David Eric. You quoted a regulation. Which regulation did you quote?
Section 7.7, road, driveways, and access standards.
Thank you.
Okay, is that, I'm not saying it's the end of your testimony, but is that, that's the
Well,
basis?
I'd just like to say it's been continuous. It's been accessed at least 40, 45 times that way. So it's not as though it's a once in a while. It's, a continual access to their property via an unpermitted driveway that doesn't meet setback requirements.
Okay, so there will probably be questions to you on that, but I'm going to now move on to the Mackenzies to comment.
Thank you. I think the board recalls that, and we've discussed earlier this evening, the Mackenzies did come in and file an application for a setback waiver.
Mr. Hughes, I thought you weren't testifying.
I'm not testifying. This is legal
but-
argument. I'm not going to be making factual presentation.
Okay,
Anyway, they applied, and the Quintons objected to that application on the grounds that they did not have an easement over the ground land in question, and they had no legal right of access where they proposed to put the driveway. So we talked to the board, and there was a discussion about whether the board could resolve the issue of who had the property rights and what those property rights were. And it was clear the board can't make that decision. So the Mackenzies have filed a suit to determine whether or not they have a right to build a driveway there. That's the legal action in which the Quintons are represented by perfectly capable counsel who could have commented on the zoning dispute. That matter is before the environmental court, and it will be resolved. Once that's resolved, we'll know whether or not the Mackenzies can put the driveway where they want to, and whether or not they have a right to cross the land where they want to. This was done at the insistence of the Quintons, who did not want their setback hearing heard because they were arguing that they had no right of access. So the Mackenzies are putting the Quintons are putting the Mackenzies in a catch-22 situation. They're saying you can't have the setback because you can't prove that you own the land. When we go to prove we own the land, they say you can't use the driveway because you don't have the setback. This is ridiculous. The driveway is not any gravel, it's grass. They drive over a field a couple of times. They're not full-time residents. There's no harm, the Quintons, resulting from this. And there would be no harm from the board letting the situation continue until the environmental court rules as to whether or not the Quintons have to put the right to put the driveway where they want to put it. Once that's established, they will come in, apply for the setback waiver if the environmental court agrees with them, and they can permit the driveway and put in a permanent driveway. But to seek a zoning violation in the interim is just a waste of everyone's time. If the board were to find a violation, we would simply file an appeal. The environmental court wouldn't hear that appeal until after the issue about access had been resolved, and probably until after this board would have heard the subsequent application for a setback waiver.
May I comment?
No, not yet. Not
Ask
yet, but thank you.
Comment briefly on the nature and extent of the use of how often they access the property. I mean, this is something, it's not plowed, it's not sanded, there's no gravel. They don't drive in the same place every time.
Yes, they do.
Hey, hold on, please.
The Quintons, Marie, please be quiet. The Quintons put large cement blocks in an attempt to block this access.
Okay, we're
the Mackenzies to drive in a particular place in order to avoid the cement blocks.
Yes.
Okay.
So I would ask the Mackenzies now to talk about how often they drive across their lawn. And I would ask the board to keep in mind that if you're going to have someone get a driveway permit for every time someone drives across their lawn, or parks on their lawn, or uses their lawn to move a vehicle to get a driveway permit, they're going to have a lot of work to do.
Okay, so Mackenzie, did you want to comment?
So this is a part-time residence, so we have not, unless she's been out there counting it, we haven't done it 45 times. We're come here about 2 or 3 times a month. We don't hardly ever leave once we're here. And so that's the only way to get on our property. And like Hans says, if anybody driving on their property, no matter where they drive, is a driveway, then that just doesn't make sense. If I drive around to the backside of my house, does that mean I need a driveway to the backside of my house because I have to deliver something there? And anything else?
No, just that I just think that we're coming here 3 times a month just to enjoy our camp. I don't think that we're doing any.
No, we're not doing anything wrong.
I feel like-
We're not inconveniencing anybody. If anything, having about 6 concrete blocks in front of our house is a bit of an inconvenience.
And there's no other choice of how we can access to even bring up and even to
How do
deliver.
we get to our house?
To deliver, and not to mention even the blocking of any type of
There's no
emergency
emergency
vehicles, or,
could
and
get
no
to our
one can get to our
house. I
property
mean-
because of those blocks, but we've never complained about it to the town because we're going through the Superior Court. I think that.
Are there questions
Mike-
from board?
Okay, there is a question. I don't know what order you go in.
Hold on one second for, right now, Mr. Coburn, we're just speaking to, I promise you, you will have a chance to speak here. But I'm going to open it up to the board members. Thank you for noting that. To board members to ask questions at this point. And again, please address your questions to whom a specific person.
Yes, yes.
Yes, I have a comment. Am I
Chip.
on?
Yes,
I believe that there's an element of this discussion that's been has not been addressed. In 1996, the property was too small to be subdivided, and Gerbode asked that it be condominiumized. Because it was too small, the condominium was approved with several conditions. That permit was never addressed or never amended. And the property remains too small to be subdivided.
but at this point, Chip, can I just step in here? We're not addressing
Well, let me
what
get to
happened.
that point.
No, we're not addressing the initial hearing and
Well,
what's
I'm
going
about to.
on. We're not going to.
All right.
Because
All right.
we're.
But let me
no,
get to the
hold on,
point.
Chip. Okay, yeah, as long as it has to do with
Well, there's a
this,
question here.
I'll speak to our lawyer here too, Mike Tarrant, to verify that I'm
Right.
correct here. Let
Let me get to my question.
Okay, perfect.
So the property was zoned as one property. It was
No,
shown with a driveway, which was included in, as an exhibit, a single driveway. And it appears that driveway that was to be continued as part of the approved subdivision has been discontinued. And I would like to know why.
But Chip, is that relevant to this particular complaint? That
Yes,
sounds
it
like
is.
it's an issue that is pertinent to the court case before the environmental court.
Well,
How is it relevant
if
here?
property was developed as was permitted, the driveway accessing both properties would be in use.
But that's not what we're hearing tonight.
That's
Chip, are you-
exactly what we're not hearing.
Can I ask?
That is, so we're not hearing it because it's not relevant tonight.
Well, it is relevant because if there was one driveway, this would not be an issue.
Exactly.
But isn't this the issue in front of the environmental court?
Well, I don't know whose issue it is, but what I'm saying is that the property was not developed as was permitted, and this driveway issue for the Mackenzies would be developed so that they could get to their property over the condominium land.
Okay, is Mike Tarrant still on the call?
Yep, I'm on here.
Can you comment on whether we're going off the rails with these? with that, talking about the historical, the history of the property and whether that's relevant here?
So the only question is the act of the ZA that was made on November 20th. And that's the issue as to whether or not the decision that there is no violation should be affirmed or reversed for further investigation. So insofar as the comment relates to that, it makes sense to go forward on it. If it has nothing to do with it, we should move on.
Okay, thank you, Mark. This is Lisa Faring, and I have a question for Danielle, if
Sure, yes.
it's my turn. Okay,
Thank
so
you.
Danielle, when you were evaluating this complaint, did you go through the records to see what driveway permits might exist for this property?
Not specifically, I guess, because I felt like I was already familiar with the situation based on the previous hearings.
Okay, so you didn't reference anything about the condominium shared driveway in your response?
No.
Okay, thanks.
May I ask Danielle a question?
Yes.
Danielle, I don't have your response letter in front of me. I can get it pretty quickly.
There's a packet in front of me.
Oh, okay. But if I recall in the letter, you said that there was never, in this area that's a contention today before us, right? You said that there was never a driveway there, at all. And it's my understanding that at some point following the DRB hearing, that gravel was put down in that space. And then perhaps you were notified about that. I'm not sure exactly what the sequence is, but the Mackenzies were told you can't do that. You withdrew your application, you know, and that gravel was either removed or covered with dirt. What's this?
So I didn't say never. I just said that currently there was no driveway, no unpermitted work done. I didn't say never. But that I know what you're referring to, and that was earlier in the spring or summer. I had been notified that a driveway had gone in, and I think you went to look
I
at
went to
it,
look at
and
it.
it wasn't there anymore.
When I went to look at it,
It was already gone, and I think what it was, my personal opinion, we were thinking that it was maybe like a temporary driveway for construction.
construction,
And then it was just covered over, it was removed when the construction was done.
which
That's,
I think was a condition of the original construction. permit.
I think that's what happened, but I never saw
Yeah.
that driveway. I just was told it was there. And like I said, when Andy went to look at it, it was already gone. So I really don't know. That's just
Okay.
speculation on my part.
Thank you.
Is the, and this is addressed to you, Danielle, from what you saw, is the driving over the grass going over where that temporary driveway, where the gravel was placed?
I don't know, because when I went up there to take a look at it, after Marie had submitted her zoning complaint, nobody was there and I couldn't see where there was no
Where the gravel had been.
detail.
You
Yeah, there was nothing that I could see as far as like, you know, a worn path or, you know, no gravel or anything like that.
Maybe that's a question the Mackenzies can answer. Was that gravel a temporary driveway for construction? And was it in the space that's being contested now?
So.
Are you asking us?
Yes, the yard was, the construction vehicles did tremendous damage to the yard. I mean, the ruts were over a foot deep and you couldn't even walk across the yard. So a common practice in excavation and replacing a lawn is to reinforce the lawn so that it isn't compactable like that and doesn't get destroyed. Was it a driveway? No, it was just reinforcement. It's just adding a little extra support to the grass in the yard so that you know?
And even the state came out.
Yeah, so the state came out and looked at it and they go, everything's fine.
Did
then
you,
it was
did-
It's not a driveway, and if that's the question.
And then it was covered back up with dirt.
It's all
after-
sod.
it's
It's all
covered with
grass.
grass.
It's all sod. You can come in the spring, it's all grass.
but was that put over the gravel or was the gravel removed?
Look, I don't even know what you call it that they did. They just call it reinforcing the yard so that it's not as soft as it was.
Okay. Yes, David.
And we still need to hear the Colburns, just as.
Yes, yep.
So this is a question first for Marie and then for the Mackenzies. I just want to, this is fairly complicated and I want to try to make sure that we're being focused on, kind of laser focused on what the key issues are. And as I understand from your testimony that there's 3 key issues here. And I would like to understand from each of you if I have a correct understanding of that. And the first issue is, was the complaint made in a timeline that's required by the bylaws? The second issue is, does the bylaw address whether or not this is a driveway? And the third issue is, are the Mackenzies in violation of a town bylaw? And so Marie, does that fairly summarize the situation as you understand it, or am I missing something important here?
I think it does, and I think after listening to Michael as well, that it's kind of gone off in this big path, and I thought that we were here to discuss the simple complaint that they were using an unpermitted driveway, a driveway that didn't meet setback requirements. That was what the complaint was for an unpermitted driveway, and that's what I thought this appeal was about, not a right of way, none of that. That's outside of this purview. The complaint was for, using an unpermitted driveway that didn't meet setback requirements. And the ZA said that they determined that and I'm quoting, they determined that the Mackenzies are not violating any zoning regulations by driving on their property because they have not installed a new driveway or completed any unpermitted work. And my appeal was that there doesn't, for a driveway to be, an access to be considered a driveway or an access, that nothing needs to be put in. It's the function and the location. If you're accessing your house from the road by driving over an area, and that's the only access that you have to it, that therefore is a driveway and therefore is regulated by town regulations that require all driveways meet setback requirements.
Great,
And they don't.
thank you.
And so that's the complaint.
And then I have the same question for the Mackenzies. Do you want me to read those 3 questions?
No, I think we understand the 3 questions and one.
Are we framing it correctly?
I believe so. We don't believe there was a timely appeal. We don't believe that driving over grass requires a driveway permit. We believe that a driveway permit is only required for a permanent access, like you would need a curb cut off of the town road. You would need to meet the construction standards, etc. As my client said, this is a part-time residence. They're accessing it maybe 2 or 3 times a month. And therefore this is not a permanent or official access. As soon as the case before the environmental court is resolved, my clients will come to this board and seek the setback waiver that would be needed to put in a complete and graveled driveway that would be a permitted installation. They have every intention of complying with the regulations once they establish the right to construct that driveway. And that's what they'll do. And I don't believe their driving across their lawn constitutes a violation of the town's zoning regulations.
Great, thank you. I'm finished.
Okay.
If you're ready to talk to the Colburn.
Any other board members have any questions? Okay, so at this time, we will open it up to interested parties. I believe the Coburns had their hands up at one point. And again, if you could address any questions or concerns to a specific person. Although we don't want a lot of we're trying to limit the give and take between parties, if you understand what I mean. We don't want, we don't have any
That's
arguments
the
going on here.
back of making it specific, right?
Yes.
So I've got some
Thank you.
feedback here in the room, but the 2 points I wanted to address were that Chip's point about the 1996 condominium.
Okay, we're
deed.
not, that's not relevant here. I think we've decided that's not relevant
That deed
here. though.
references the original sale of the property from the Quintons to Phil Gerbode in 1985. And that deed specifically states that we have access from the western to the eastern border of Briarcliff Drive, that entire northern border of our property, we have access from Briarcliff Drive. And so the blocks that are deed, and we expect that there will be action taken on that when this is heard in court. And
That's not relevant to tonight. Can we keep
the
it
other
to
issue
tonight?
is simply that the use that the Mackenzies are using their property frequently, I think is just ridiculous. They're using it only a few times a year. They're using it in a way that is restricted by those blocks. And so I think to complain about the use of their accessing that property the way that they are, without acknowledging that part of that is dictated by the placement of those blocks is ridiculous.
Okay, thank you. Sorry, just taking notes here. Do you, Andre, Karen, do you have comments?
I did.
Questions?
I'd like you to ask, or Danielle, when there was a complaint about the propane tanks on the Mackenzie property, how did you access that property?
I parked on Briarcliff, I believe, and walked.
And did you happen to see tracks around the red building?
I don't believe so, but I wasn't looking for them. But I wasn't sure where to park, so I just kind of pulled off a little bit so that I wasn't blocking access to Briarcliff. It was actually two of us were there. I was there with the assessor and we both just kind of like pulled off to the side and then walked through across the grass to access the property.
So they keep bringing up the concrete blocks. We did put the blocks there as they were driving over the private property. And there was an issue, so we put the blocks there. But we did not want them driving on the private property. So they keep bringing up the concrete blocks. I put them
On your property?
on my property. It's within 3 feet of the boundary line. It's not actually right on the boundary line. If I moved them to the property line, they wouldn't be able to access.
Okay, thank you. Are there any other questions from the, comments? Yes, Marie.
So just because I am the applicant here and I just feel like everybody's given opinions and we've kind of not, I guess my question for the board is what constitutes a driveway in the town of North Hero? Because although someone may only come up once in a while and it is inaccurate, we do know of, going in and out. And I've submitted photos that showed where the driveway is. That was in the zoning complaint. If one was to drive out there, there are ruts there. And irregardless if it bothers someone, if it doesn't bother someone, if it looks nice, if it doesn't look nice, regulations are regulations. And if you're accessing your property a certain way, it is therefore an access point in the regulations, and that is a driveway. And it must meet setback requirements, irregardless of what everything else is going on. If this case goes on for 2-3 years, this outside case that doesn't have to do with this, then you're allowing someone to use an unpermitted driveway that doesn't meet setback waiver simply because it's easier. And if, the town is to set precedent that you can drive over a lawn to get anywhere, no one's going to get a driveway. And you know what? What's the point of setback requirements? Someone can drive along your property line nonstop to reach their house under the auspices that there's no gravel put in. But that's not what the regs say. The regs say access. It does not say what kind of material needs to be put down, that anything needs to be put down. If you're using something according to function and location to get from the road to your house, and that is your access, that is therefore defined as a driveway.
And
that's in the
Marie,
regs.
you've made this point 3 times. Is there any additional information that you need us to have?
Yes, and the fact that they're only coming up a couple times, they're going back and forth, and if needed, we could submit documentation of, 40 times in the past 6 months. So it is being used more than just, if you're going in and out, and yeah, that.
Okay, thank you.
Yes, Christine.
So I'm looking, Andre had me open up attachment B, it's called, exhibit C, I think it is. So I see the blocks, and you said you're within 3 feet of the property line. So it's the grassy area, the strip there that comes off Briarcliff. That is where they're driving in.
Between those blocks and the buildings. They go around that building as tight as they can, within 2 feet of.
Oh, I see a picture with a car. So it's that little strip in there.
If you look at the color version,
Oh.
Danielle sent,
Today.
Yes,
you can see the lines.
I can do that. I
I
have
mean,
that.
we had the
I have-
black and white version, but it's much easier to see it on the color version.
Yeah, I'm.
So it's
glad you brought that.
exhibit.
Got it.
D. Exhibit D, the colored version shows the path.
And is that Briarcliff Road between between the big red buildings? That's the road, right? The main,
Well, Briarcliff is,
is this Briarcliff right here?
The Briarcliff is between the barns?
Yes.
no. But
Here,
Briarcliff isn't.
Andre.
between the barns.
This is Lisa Faring, right? I'm sorry, can you just explain where to get the colored version of Exhibit
This
D?
Briarcliff.
Danielle
Yes.
emailed the colored version today.
And so they
As an
kind of, if they're
attachment.
coming, they're
As
coming
an
like this.
attachment today?
No,
Okay.
they're coming
Yeah,
along
it's
this
an email.
building. and coming
I can
down.
tell you the.
I'm just,
That's why
oh,
they're
okay.
turning.
Okay. Okay, we were
What's
looking
this-
at it.
What's this road here?
That's
That's
Briar.
That's,
Briarcliff.
okay, that's the word, okay.
From those blocks to
Um,
Briarcliff. is
yep.
our pro-
See, I was getting
Email
confused,
at
Andre, because this car's going in, they're just going out in this picture.
Correct. They've got to turn around, turn
Yeah,
tight
yeah,
on
yeah,
that
yeah.
building. Around that building.
Okay.
Okay, if there are no further questions, I'm gonna ask for a final comment from Marie and a final comment from the Mackenzies. Are there further comments? Or questions from the board? Okay, hearing none. Marie, do you have was your comment considered a sort of a final comment, or do you have? Okay, Mackenzie's, do you have a final comment?
I would only say that, as Marie said, regulations are regulations. She wants you to strictly enforce the regulations when it comes to the location of the driveway, the alleged driveway. She wants you to give her leeway when it comes to enforcement of the regulation with respect to the timeliness of the appeal. She can't have it both ways. I think the board should be reasonable in both circumstances. The Mackenzies came in, they sought the west setback, they sought permission to build a legitimate driveway. If you read the records, the Quintons violently opposed that application and said that the Mackenzies first have to go to a court and prove their right of access. So we're doing exactly what the Quintons suggested. Had the Quintons not raised that objection, we could have heard a setback application and had the driveway approved. But instead, we went the route of establishing our property rights first, and that's what we're doing. And no harm will be done if they drive over their lawn once or twice a month over the next year while this is being resolved.
Can I also ask a question too? I mean, my understanding is that the reason for zoning regulations is to control the building of structures on properties. And obviously a gravel driveway is a structure, a house is a structure, a garage is a structure. I understand what it says in the zoning regulations about access, but are you also in the business of controlling how people's access to property is? In other words, are you going to enforce throughout the town that anybody accesses their property outside of an actual approved driveway is now illegally accessing their property? Is the purpose of zoning, is zoning all about where and how we access our property, or is it about whether or not we build something on our property? I thought it was built structures that zoning is about. And that's all.
Okay, thank you. I think at this point, with no further new information or questions, somebody would like to make a motion to,
Do we close or
Did-
do we,
I,
what do we do on an appeal?
on an appeal, do we close it, Mike?
Yeah, that's fine. Close it and we'll go into deliberative session and issue the decision in the time frame under the law.
Okay, so let's have a motion to close.
I move that we
Actually,
close
this is Lisa
Oh.
Farren. Can I ask one more question?
Sure.
Okay, so this is to the Mackenzies or their attorney. Your understanding is that you did not have a permit to use the driveway. That's why you went to the environmental court. That's why you came to us first, and then went to either the Superior Court or the environmental court, whoever you're using to adjudicate this. And you do not believe you have any other rights to a driveway other than that. You have no existing permits. Is that
I'm not sure I understand the question. No, we do not have a permit for a driveway in that location. That's the application that was withdrawn while we resolved the ownership issue. We contest that we have the right to put one there, but we are gonna have to get a court to say that we have that right.
Okay, great. Thank you for clarifying that. I don't mean to be pedantic.
And I have one final question of the Mackenzies. I don't know if Mr. Hussey was your attorney, but I'm curious, did anything come up in the title search when you purchased this property that would indicate you were gonna have a problem?
You're on mute.
Oh, there
No.
was nothing we've had, yes, no, there was nothing in the title search that indicated anything was wrong.
So from your point of view, the land boundaries and your ownership to the land and whatnot was very clear in the title search?
Very clear, no problems. It's all made up problems.
Okay, can we have a motion to,
Yeah, I move that we close the hearing,
David
Yeah,
moved, do we
yeah.
have a
close the appeal.
do we have a second?
Second,
Chip seconded, all in favor, say aye.
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 Opposed? Okay, so the hearing on the appeal is closed at 8:25. We will start deliberations on this evening and get a decision out. I want to thank you all very much. And I thank everyone for being respectful tonight. Thank you. I know this is not easy for anyone, so I'd like to thank everybody.
Thank you. Thank
Thank
you.
you.
Thank you.
How do you see it?
You want your sheet back? Unless you want to keep digging up.
So Danielle is now taken off her ZA hat and put on her clerk hat. I need to find my, oh, it's right in front of me, our agenda, yeah.
And just a quick question, you gonna
Yep.
want me here for the discussion?
No.
afterwards? Okay.
No, you're all set.
He wanted to share something, though. We didn't get.
No, you guys covered it, so it's,
You think?
I'm fine, yeah.
Okay,
We're good?
okay. Thank you all. Good night. Good night. Approval of the minutes of December 12th, 2024.
I have copies if you need them.
I have a copy here. Anybody?
Yeah, I'll take that copy.
Here, I've got extras.
Oh.
Hey, Diana, before you guys move on to the next item, I know you said you were.
Thank you for being here, by the way, Michael.
Oh, you're welcome. Before you move on to other things, I just wondered, you said you were intending to proceed to deliberative session, which of course will be closed to the public, but did you want me to stick around or do you want to just talk another time?
does the board feel like it would be helpful to have Michael as part of the deliberations, in which case we can do this one first, or do we have enough information to proceed without Michael?
The one I'm concerned about is the timeline.
Okay, do you mind sticking at least, we'll hear this one first and deliver, it will be done in 5 minutes here.
Yeah, that's fine. I didn't know what the plan was, so no worries. I'll sit tight for 5 more minutes and then we can
Okay.
go from there.
Cause I have to take notes about the deliberation.
You're gonna have to go downstairs.
I'll just go and wait.
Yeah.
Okay.
Yeah.
Okay, so minutes, do we have a motion on the minutes?
You okay?
Oh, yeah, that's good, yeah. Yeah, I move to approve the minutes.
I second.
Patty moved to
This is-
approve.
Oh,
This is Lisa. I have a correction.
Oh,
Okay,
Well, I believe in the first hearing, 105 DRB, Chip raised the issue of the small lot
He
and
did.
setback.
Yeah, he
And,
did.
and, I thought we were going to go and get some clarification from VLCT on that.
I think that's, I don't. I don't remember that, but I don't think that, I mean, that's certainly something that we can discuss. When we're talking about, regulation clarification, but I think at this point, we're just, I don't know that that's relevant to the minutes here. We have a motion,
I thought there was an action item on the table. So.
okay. We have a motion to approve the minutes. All those in favor?
aye.
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 Opposed? Okay. Okay, so minutes approved. So a ZA report, do you have anything that's really?
No, nothing
No.
really. Did not issue any building permits, in December. The only thing that has been, coming in are, certificates of compliance and certificates of occupancy. So I've been doing a lot of site visits and signing off on a lot of those. And that's it.
Okay, so, thank you. Any other business? So we're going to go into deliberative session at 8:29. After Danielle stops the tape, she will leave the room. She can go downstairs and then we'll come get you, okay?
Sure.
Oops. We're keeping Pat.
Thursday.
Okay, the board is out of deliberations. It is 9:44 and I will accept a motion to adjourn. Patty moves. Is there a second?
That we adjourn.
Second.
David seconded. All in favor?
Leslie.
Aye.
Aye. All opposed? Good night. Now we are adjourning at 9:44.
Thank you, Diana.
Thank you. No,
Thank
thank
you, Diana.
everybody.
Thanks, everyone.
You put a
you.
ton of effort preparing, and it really showed.
Good night, Lisa. Chip. Chelsea.
The whole,
Good night, folks.
Yelsey, hope you feel better.
the whole intent was